Hi, everybody. I'm Melanie Hammelman. So what we're going to go over here today is sort of estate planning basics. If you have any questions, like Jeremy said a little while ago, just feel free to enter them into the chat section. And if it's something that refers specifically to a slide, he'll go ahead and let me know when we're on that slide. And if it's a general question or something that you think of later, on in the presentation, then he can go ahead and ask me at the end. There'll be a little bit of Q&A, so y'all can ask any questions that come up. I am going to go ahead and start my presentation. Okay, so again, I'm Melanie Hammelman from Hammelman Law. Sorry, you're probably going to see the light changing. I'm in front of two big windows, and so sometimes whenever the sun goes down, things get dark or bright. All right, so if at any point you need to get a hold of me, you can reach me at, you can go to the website, hammelmanlaw.com. There's an information page for you to fill out where you can ask for quotes and things like that, or you can just ask simple questions. My email is also on there. It's melanie@hammelmanlaw.com, and I'm always happy to answer questions. All right, so first we're going to go over sort of the just general stuff about estate planning, like what is an estate plan, right? So an estate plan, most people think of just a will, but it's really a collection of documents that tells your loved ones what you want whenever you pass. It actually can express your desires for when you pass, or if you're incapacitated. It can also, tell what you want to do, how you want to give assets, or if you want to pass assets to your children, to your grandchildren, parents, charities, what you want to do with pets. If you have pets, I actually was just right before we started this conference call or this webinar, I was working on a trust that factored in my client's pets. And, it can also be, if you don't have children, you can leave things to nieces and nephews. I have children and I still left things to my nieces and nephews. So it really is totally your personal preference, how you want to handle leaving your assets. But basically what you're getting to do in your estate plan is tell everybody what you want, so that you haven't, worked so hard for all these assets for them to not be handled the way that you wanted them to be. All right, so now we're going to get into sort of what the documents are. So who needs an estate plan? Everybody, right? Of course, that's what I would say. I'm an estate planner. But really, everybody does need one, just so you can tell, like I said before, just so you can tell people what you want. You can tell people what you want to be done with your assets. And also so you can sort of decide how the court handles your assets. Whoops, let's go back here. Why should you make a plan, right? So you get to decide what happens. It also allows you to make decisions like who gets your children if something were to happen to you. That's a super important thing to deal with if you have minor kids like I do. And it's also a way that you can account for adult children if you have special needs children, or if you have, if you have a strong relationship with grandchildren, or even have, legal guardianship over grandchildren. You can decide what happens, in that situation. It also, so we had to go through this a couple of years ago with my grandfather when he passed. It also helps really eliminate stress from the family. So nobody's left wondering, what should we do? How should this be handled? Who gets this? Who gets that? Especially, I tell people all the time, especially if you have specific items that you think people are going to want, put down who gets it. That way there's nobody fighting over stuff after you're gone. Immediate access to assets after your death. So that comes into play in some of the documents, but not in others. Anything that goes through probate, which is a scary word that people have heard that a lot of people just don't know what it means. If your assets go through probate, sometimes you don't have people who are taking care of your assets, sometimes they don't have immediate access to them. If you have a trust, they do. So that's something we'll sort of get into those kind of nuances in a little bit. Added bonus, taking inventory of assets. I have had more than one client say, oh man, I forgot I had this account, or, oh, I actually did get something from my dad, and I forgot to consolidate that into my other, savings account or investment account. So it sort of allows you to take that inventory. I also, for my clients, generally provided an electronic inventory or an electronic asset inventory form. So you can sort of go through, and if you have one of those password accounts like LastPass or something where it's a password manager, you can enter that information in there so that people know how to access all of your accounts. If not, it gives you a place to sort of indicate like the websites you have accounts on, the important ones, like maybe not everybody needs your Amazon password, right? But maybe they need your password if you have, like I have an iCloud account that has all the pictures of my kids on it. So I would want to give that to somebody. So it allows you to sort of write down all that information and make sure that it's easily accessible for people who might need it. Okay, what happens if you don't plan? I get this question a ton. Like, do I really need it? Why? What happens if I don't go ahead with this? So if you don't even have a will, then the judge really gets to decide, which is not great in most situations. If you have kids and the other parent is still alive, then it's generally fine. If you have kids and you haven't indicated who gets them and the other parent, either there's not another parent, or if the other parent isn't around, isn't involved, doesn't want to be around, if you don't indicate who gets the kids, then the court really has to sort of go through all of your friends and family members and decide on their own who gets them. People you don't want in charge. I have gotten this one a number of times also. Somebody says, hey, I really love my sister, but I just don't think that she's going to be able to be level-headed during this time. If I'm either incapacitated or if I'm deceased, I don't think she's going to be level-headed. Or, I think my sister would be fine handling that, but I don't want her to manage the money. So there's tons of ways for you to, identify who you want to be in charge of certain things whenever you pass or you're incapacitated. Dependents can get money before they can handle the responsibility. So that basically, if you don't have something in place, your dependents, so your kids, grandkids, whomever you're a legal guardian of, would get the assets that they would be receiving through inheritance from you. They would get it at 18. This is the same example I use all the time. If you've seen me, on one of the presentations before, or if we've talked before, you probably already know, the little shtick I generally go through. I was a pretty responsible 18-year-old. I still should definitely not have been trusted with a big stack of cash, right? Which is essentially what an inheritance is. Generally, assets are liquidated other than, personal effects that are important or meaningful to people. So it's basically like handing an 18-year-old a stack of cash. So, a couple of things are going to happen. One, you're going to get the very rare responsible 18-year-old. They're going to be able to handle it. They're going to seek help. Great. Usually what's going to happen, though, is you're going to get an 18-year-old who takes this big stack of cash and buys a tricked out Range Rover, right? Nobody wants that. You want to take the money that you've worked so hard for. You want to save it. You want to make sure that it benefits your kids long run, takes care of their education or health or, whatever is important to you. You want to make sure that that money is there for them, just like it would be if you were around to, pay for those expenses for them. Tax consequences. So depending on what sort of estate plan you have, the tax consequences may factor in. Depending on the size of your estate, they may factor in. That's something we'll sort of tackle a little bit later on. Loss of privacy. So any of your assets that do go through probate, whether it's real estate, whether it's just personal effects, everything is public information. So anybody could go, look up your probate proceeding and see what assets you had and who they want to. Some people don't like that. What else can it include? So this is sort of what I mentioned earlier, death versus incapacity. So death, obviously everybody knows what that is. Incapacity is when you're incapacitated in any number of ways. So generally people think of incapacity like being in a coma, right? That certainly is a form of incapacity, but also you're thinking more long-term too, like dementia, Alzheimer's, any sort of chronic condition that can cause changes in like the brain that can keep you from being able to make sound decisions on your own. So for death, you're looking at things like a will, which is generally what everybody thinks of when they think of estate planning anyway. A revocable living trust, which actually, you know, we provide for incapacity in there also. Revocable living trust is sort of your basic catch-all trust. So that's like where you get to decide how the money is used and how much, what percentage goes to each kid, whether you're going to pay for weddings or college, or, you know, what you want to happen if your kid gets married and then divorced. How do you want the assets to be handled? Things like that. Irrevocable trust. I've been doing a lot more of these lately. Most of them are either for special needs or for life insurance policies. Because of the estate tax changes that are coming, a lot of people are wanting to do an irrevocable life insurance trust so that you can sort of separate out the different assets that you have and keep that taxes to a minimum. So basically in an irrevocable trust, you're saying, this is what I want done and I can't change it. Which if you're leaving things to your kids, it's totally fine. Even a spouse is totally fine. You generally can, you generally want to include, if you're leaving it to a spouse, that it should only go to the spouse if you and the spouse are still married at the time of your death. It also keeps the beneficiary of the trust from being able to borrow against it and things like that, which is generally a pretty good idea, especially if you're leaving it to kids. And you can also identify who you want to manage that. So if you want to leave a life insurance policy for the benefit of your kids, but you've got minor children like I do, this is a good vessel for managing that. You know, you can make sure that they're the beneficiaries of it, but they won't actually have control over the funds until they're, you know, whatever age you want them to be before you think they're responsible enough to handle that. Death, beneficiary designations. So that's like a life insurance policy. You're going to designate who gets the funds. You can designate something like a life insurance trust, or you can designate a person. A lot of times what I tell people is feel free to designate your spouse first, and then we can always indicate that the trust is the contingent beneficiary. You can receive, you get sometimes a little bit better tax benefits or spousal benefits if you pay it to the spouse first. So a lot of times we do go ahead and list the spouse first, and then the trust is a contingent. Personal property memorandum, that's sort of what I was talking about earlier, where you get to leave certain items to certain people. Retitling of assets like real estate. And then we've got some incapacity documents over here, and I actually think we're going to get to all of this a little more in detail later. Okay, so the will. The will, like I said, this is your cornerstone document. This is the document that everybody thinks of when they think of an estate plan. The will lays out your distribution of assets, similar to a trust. You can say, you know, who gets what percentages, who gets certain amounts. It can be any combination of those. So you can say, I want everything to go 50-50 to my kids. Or you can say, you know, I want to give $10,000 to my sister because she's going to be the executor. I want to give, you know, a family heirloom to her daughter, and then I want everything else to be split between my kids. So you've got plenty of options, but like we discussed earlier, everything will go to your beneficiaries at 18, unless you build in some trust mechanism. You can also identify what happens for your debts, taxes, and expenses at your death. So generally, you want the executor to be able to settle up anything that has to be settled up. Some debts are extinguished on death, so some of them, you know, will the executor will automatically be sort of cleared of having to deal with. The executor is the person who handles that distribution. So that's the person that you would identify and say, I want this person to manage dealing with the court. So they can still hire an attorney. Generally, the estate would pay for the attorney. And then the judge would just sign off on the executor distributing the assets as you have indicated in the will. Guardians for minors and for incapacitated adults. I definitely wrote incapacitate adults there, but it's incapacitated. So this sort of goes back to what we were saying earlier. If you do have minor children, if you have custody of your grandchildren, even if you have adult children who are special needs, then you can provide for who should be their guardian whenever you're gone. Beneficiary is just a fancy term for who gets what. Testamentary trust. Okay, so testamentary trust, it's sort of like a baby trust. It's actually a trust built into the will, but you can't be as specific with it as the revocable living trust that we talked about earlier, that we're going to go over a little bit more here. So in a testamentary trust, you can basically say, these are the people that I want my stuff to go to. I don't want them to get it at 18. They can get, 25% at 18, 25% at 22, which is approximately when they would graduate undergrad. And then, the balance, the remaining 50% at 25, something, 30. So you can sort of lay out a little bit of a delayed distribution. You just can't be quite as specific. The revocable living trust is, if you want to be more specific, this is where you want to be. So the revocable living trust, you can specify who you want to be the trustee. You and your spouse, if you're married, generally are the initial trustees. That way you get to keep living your life. It doesn't change anything. It doesn't change how you write checks. It doesn't change how you use a credit card. It doesn't change anything. And then you can identify a trustee after that. It does help avoid some familial conflict. I generally recommend to people also, if you have a certified financial planner, if you have a financial advisor that you trust, if you have somebody like that, you can also designate that person as a trustee. It's a good choice. They are generally pretty prudent with finances. I mean, that's their job, right? Hopefully they're pretty good at it. They also are used to, managing things for people. Okay, so they're used to having to balance sort of what they think is best versus what the client wants to do. So that's a really good choice if you feel like, oh, well, I'm not sure who I think would be the best fit for that. That's something to talk through with, with your estate planning attorney. Make sure that, they know that you have a financial advisor that you trust, and maybe talk about whether they may be a good choice for that. Asset management during life and after death. So I get this question all the time. Does it protect assets? No. So what it does is it allows you to sort of have a place where you can congregate all of your assets, which is generally fairly helpful. Like I said, a lot of times people realize, oh, I have more than I thought, or, oh man, I forgot about this account over here that my parents left me. It will not protect assets for you as the person who is having the trust drafted. You will have no asset protection. I have no asset protection in my own trust that I have set up for my husband and I for the benefit of our kids. What it does, though, is it offers protection to your beneficiaries. So once all the grantor is the person who's having the trust drafted. I don't know why they're, why they still use these archaic words, but that's where we are. So once the grantor or grantors, if it's a married couple, once they have both passed, then it cuts off any ability for creditors to get to the funds. So if your beneficiaries rack up a big credit card debt, right? Or if they have big medical bills, or if they get married and subsequently divorced, those assets are not available to a creditor, to a medical creditor, like a doctor's office, a hospital, anything like that. They're also not available to an ex-spouse in the event of divorce. This is a huge reason why I tell people, if you have a trust, use the benefits of the trust, right? So don't just say, once my kids turn 25, they get all their money outright. It doesn't need to be in a trust. Leave it in there. Leave it in the trust until the end of time, and just say that once they turn, fill in the blank age, that they have the ability to use it as they see fit. Because then anything that they've actually withdrawn, if they've taken out, say they have $500,000 in there that you have left for their portion. If they have taken out $50,000 and just stuck it in their personal bank account, then that $50,000 would be available in the event of divorce. But the $450,000 that's still in there is not available. So it's best really to just leave stuff in there, and then just allow them to be their own trustee at a certain age. Once they get to an age that you think they should theoretically be responsible enough to manage it. Flexibility, like I said before, you've got tons of options in a revocable living trust. You can say, I want it to be used for college. I want it to be used for grad school. I want them to be able to, start a business with it. I want them to be able to go to vocational school. Really anything you can think of. You can also set up, specific portions or specific allotments for things like weddings, down payment on a house. I've had tons of people lately have wanted to provide for, for weddings and for down payments, especially with the real estate market being so crazy. And, if it keeps going up, nobody's going to be able to afford a house on their own. Avoid probate. So anything that's in your trust does not go through probate. So your trust is not filed publicly. All the judge wants to see is, oh, yep, look, they do have a valid trust. Okay, looks good to me. Sign off, and then they'll sign off on the trustee just managing distribution of assets from there. What does a revocable living trust not do? Okay, so this is what we talked about a minute ago. Did you want to jump in here for a sec, Jeremy?
Yeah. We just had a question come in.
Sure.
If someone has a living trust, do they need a will as well?
Yes.
Okay.
So basically, they sort of go together. So what happens is you have a trust. It sort of gets weird, right? The court doesn't know you have a trust until something is filed with the court. So whether you have a will or a trust or nothing, your death certificate has to be filed with the court. What happens when you file a death certificate with the court is it opens a probate case. So when people say it goes through probate, that just means the state or the county is taking inventory of what you had and making sure it goes somewhere. And if it doesn't have somewhere to go, then the state takes it. So if you have a trust, you still have to have a will, because you want to be able to tell the court in that will, I already have a trust, so go ahead and do everything through that. It makes it so much faster. It makes the probate case so much faster, and then it gives people access to your trust quicker. So if they needed the money to take care of your kids, if they needed the money to take care of your elderly parents or your pets or whatever it is, they would be able to get to it quicker. So we'll get to this in a minute, but since you asked the question, I'm just going to go ahead and sort of give you a brief overview of what I generally do for people that get a revocable living trust. I include a will with it because I don't think it makes sense to give you a trust if you don't have a will. The type of will that you get with a trust is called a pour-over will. It's got what I call a straggler provision in it, right? So it basically says, I already have a trust and I already said in the trust how I want everything to be handled. All my stuff should already be in there, but if I forgot something, go ahead and put that in there too. And then what that does is it allows the court to, again, take a look at that trust and say, oh, yep, that looks good. Okay, you've got a valid trust. Oh, but you did forget this thing over here. So we're going to go ahead and title that to the trust also. And then everything just, is handled the same way. Everything that you sort of forgot is handled the same way as you indicated you wanted your stuff handled in the trust. Okay, so let's get back to what does a trust not do? No protection against cost of long-term care. So if you don't have long-term care insurance and you are concerned, if you have early onset dementia, something like that, if you find out you have stage 1 cancer of some sort and you decide you want to start planning for what happens if things progress, what you need if you want to essentially insulate your assets or protect your assets from being able to be used for your medical care so that you can qualify for federal aid, what you would need in that situation is an irrevocable trust. That goes back to sort of what I was saying earlier. Usually when I draft those, it's for special needs or for life insurance, which is a totally different animal kind of. But for special needs, generally that's someone that qualifies for federal aid. And so you want to be able to provide for them, in case there's not enough federal aid or in case, for their everyday living expenses like groceries, things like that. But you don't want to give them so much. You don't want to give them enough control over their assets that they then don't qualify anymore for those federal aid programs. It also has no effect on the creator's income taxes. It doesn't change your tax bracket. It doesn't change anything. It's just, a schedule that you file on your income taxes once you've actually moved stuff into there. Which frankly, I generally tell people the only thing to go ahead and stick in your revocable living trust while you're still alive is your real property. And then everything else, even for myself and my husband, we just did payable on death beneficiary designations so that once the second of us passes, it then dumps directly into the trust. Additional information. All right, so this is what, this sort of goes back to the question that Jeremy just asked. So this is the pour over will. It has this, straggler provision. The only other thing about a revocable living trust that you need to make sure of is that it's funded. So this is has been a major problem with people who draft trusts but don't do estate planning. So like an attorney that does, say it's a family law attorney and they're like, oh yeah, I can draft that trust for you. Some of them can, and some of them are very good and very proficient. But if it's not an attorney who does estate planning as a regular part of their business, don't do it. Because what happens is if the trust isn't funded, you've got all this beautifully written language, and then it doesn't mean anything, and the courts will say this isn't valid and just kick it out. And then you either go back to the will, which, again, in my case, I do this pour over will, and it says, hey, if for any reason the information in this is deemed invalid, then take the terms of that trust and use it to distribute my assets through my will. So it's sort of a, catch-all provision both ways with the pour over will. But if it's not funded, then there's no trust. Generally, I use what's called a magic wand provision. It basically just says, any tangible personal property I own, so, clothing, jewelry, furniture, anything like that, upon the signing of these documents belongs to my trust. So that's sufficient to fund a revocable living trust. Don't put retirement assets in there. The only time you want to put a retirement plan in your revocable living trust is if you honestly have nothing else that you can think of to do with it that would save you from the massive tax consequences. Generally, if you indicate that the trust is the beneficiary, all the taxes on it are going to be due up front because it's all considered paid out because it pays immediately all into the trust. Whereas, it would be over time, sort of, if it's, if you're doing those RMDs or if you're paying out periodically to the beneficiaries. So in some cases, I have advised people, like, if you don't have anywhere else to put it and you got minor kids, just, list your spouse as the primary beneficiary and the trust as a contingent beneficiary. It's not ideal, but you can go back and change it later. You can go back and change it as soon as the kids are old enough to deal with it. Because, the idea here is these are ways to handle property if we're not around. We want to be around, though, right? That's the ultimate goal. So whenever the kids grow up, whenever whoever it is that you're leaving assets to in your retirement plan, whenever they, get old enough or, are responsible enough to manage that, then just go ahead and change those beneficiary designations. Irrevocable trust. Don't do this unless you have a life insurance policy that you're putting in it and it's just for life insurance proceeds. You've got special needs, either children or other individuals that you need to care for, or you are old enough that you seriously need to consider long-term care and Medicaid planning. If you do this too young, you end up in a situation where one of my clients was, and they were trying to get out of it, and it's super difficult. It's doable. It's hard. So you don't want to be in a situation where you're, in your early 60s, you're fully capable of taking care of your own, taking care of yourself, writing your own checks, paying your own bills, living your own life, and then you're having to call your kids to write those checks for you because somebody talked you into an estate plan that wasn't right for you. Okay, so now we're going to get into some of the other documents that are mostly for incapacity. So durable power of attorney. This is also called a financial power of attorney. It's basically the person that takes care of your finances when you're incapacitated. Again, we talked about that can either be, if you're in a coma, if you have dementia, if you have Alzheimer's, even if you have, like with COVID. So this has been a real concern lately with some of my clients. With COVID, there's this brain fog thing, right, that has impacted some people. I'm not going to purport to know the numbers here, right? But this brain fog thing, my clients have been genuinely concerned that, I'm going to get this. I'm not going to be able to make my own decisions and manage my own affairs, and I don't have anybody to do it for me. So it just allows you to identify who you want to manage your finances, and also to identify what it takes for you to gain that control back. So the Britney Spears thing has also been brought up by a couple of my clients in the past, I don't know, maybe a year or two. And they've said, how do I get that back? Like if something happens, if I'm, deemed incapacitated, how do I regain capacity? So that's something you generally want to outline in there also. Like, what does it take to get that back? And that's an important thing to do, especially if you have minor kids. Especially if you have had to have someone else take care of your kids while you're incapacitated. You want to get that ability back. You want to get the kids back. Okay, so a lot of people ask about this. A lot of people ask about what happens with the trust when you're incapacitated. So mine generally overlap the durable power of attorney and the trust. Why? Because you've laid out all these beautiful plans in your trust. If you have a trust, you want that to be utilized if you're incapacitated. You want the trustee to be able to take care of you, but also to be able to utilize the assets in your trust to take care of your dependents and use them for the purposes set forth in your trust. So, weddings, education, healthcare, things like that. I generally recommend making the person who is your durable power of attorney and your trustee the same person. If you're married, generally the spouse is an easy choice, but I usually recommend making those the same person because they do overlap a little bit. Either that or you need to remove some power from somebody. So if you don't want to make them the same person, you either have to remove that incapacity power from the trustee, or you remove certain powers regarding certain assets from your durable power of attorney. That way there's like nothing conflicting, so the courts know what to do with it if, you know, something has to be filed. Medical power of attorney sort of goes back to the durable power of attorney. It's just the same thing, but it's the person who makes your medical decisions whenever you're incapacitated. This could be, you know, temporary incapacitation, you're in surgery and they, you know, need to make a decision. Generally defaults to the spouse. If you're married, not a huge issue until until your spouse is gone. I don't know that I touched on it on the last slide on the durable power of attorney, but they can both be what's called, they can both be effective immediately, or they can both be springing. So springing just means that it's not effective until you're incapacitated. I'll tell you, for me, I have it effective immediately for my spouse. But if it's anyone other than my spouse, so if he's predeceased me, then it's not effective until I'm incapacitated. And that's a pretty common choice for married couples. It also allows you to sign, to put a HIPAA release in your medical power of attorney so that you can say, look, I want this person to have access to all my medical records. I want them to be able to, you know, receive all the information they need to receive, talk to all the doctors, things like that. You don't have to give them that. You don't have to sign off on that HIPAA release in the medical power of attorney. It's generally, the doctors can fight a little bit if you have indicated that you want this person to make your medical decisions, but you don't want them to have any records. It makes things a little difficult sometimes, because then they feel like, well, can we tell them what's wrong enough to be able to give them the information that they need to make the decision? So I generally incorporate the HIPAA into the medical power of attorney just to keep things sort of streamlined. Pregnancy clause for females, you want to be able to say, you know, I want my medical power of attorney to be able to make any decisions necessary unless it compromises the fetus, or even though it may compromise the fetus. So, you know, that's something that a lot of women are interested in, you know, making their intentions clear there. Other medical decisions. So it will, like I said, down here at the bottom of the screen, HIPAA authorization. I usually build mine in. I just think it makes it easier for doctor, for you as the, you know, patient and client. Living will. So the living will is where you say what you want to happen if you are in, you know, either a permanent vegetative state or if death is imminent. So if you have, you know, permanent vegetative state, I mean, we can all sort of identify what that is. But the imminent death from a terminal condition is, say you have stage 4 cancer, and, you know, maybe you are alert, but maybe you are intubated, you can't talk. So this is where you get to indicate what you want. So do you want to be kept on life support? Do you want to be do you want to be kept on life support for 30 days and then have, you know, be removed from life support, stuff like that. So it allows you to make the decisions that you wouldn't want to sort of burden somebody else with making. So like, I don't want my husband to have to make that decision, because I think he would have a tough time, you know, terminating life support, and I don't want to necessarily stick around to be a burden to him. So it just allows you to make sort of your own decisions there. Pregnancy clause again, if you are pregnant and you're in a situation like that, do you want to be kept on life support until the baby's viable, or do you want to just go ahead and, you know, utilize whatever other decisions you've made for yourself regardless of pregnancy? Other actions. All right, retitling assets. The two biggest things for retitling assets are real property and bank accounts. Real property, I generally go ahead and tell people to put their real property into the trust. There's no reason not to. It doesn't change how you sell the house. It doesn't change how you buy a new house. doesn't change anything, just makes things a little simpler on sort of the back end. So like after you've already passed. People ask me all the time, I have 3 investment properties. Should I put those in the trust too? No, definitely don't do that. The investment properties should all be totally separate. Even if you decide not to get an estate plan with me, don't have your investment properties in your own name. Have an LLC formed, put all of your investment properties, at the very least, put them all in one LLC together. Depending on the value of the property and the location of the properties, you may want to put them in separate LLCs. Basically what that does is it keeps somebody from, slipping and falling, having an accident at an investment property and then trying to seize your personal assets. Nobody wants that. So definitely keep those separated. Bank accounts, like I said before, I generally don't recommend transferring title to your checking account. Just do a payable on death or transfer on death, beneficiary designation, have it pay into the trust once you pass. Investment accounts, you could go ahead and transfer. You're probably going to have the same investment account. Like I said, it doesn't cause any issues anyway. You're still going to be the trustee. You're still going to have control over the assets. It can make it a little quicker on the back end if you go ahead and change title to things like investment accounts, though. More beneficiary designations. We've been talking about these, I feel like, for a while now, starting with that life insurance trust. So life insurance and retirement plans, just do something with them. Just make sure your beneficiaries are who you want them to be. You don't have to have a trust. You don't have to put these in a trust. Retirement plans probably shouldn't. Life insurance, you don't have to have a life insurance trust. Just make sure it goes where you want it to go. That's really sort of the underlying theme of this whole presentation is you just want your assets to go where you want your assets to go. I'm not trying to sell you on an estate plan. I'm just trying to make sure that, the stuff you've worked hard for gets where you want it to go. Again, if you do a beneficiary designation, this is sort of what I was talking about with listing the trust as a contingent beneficiary after a spouse. They can take at 18, they will take at 18. So a lot of times I do have clients who say, look, I'm just going to list my trust as the contingent beneficiary. And then once their kids are, 30, 35, 40, however old they feel like they need to be before they deem them responsible adults, then they change those beneficiary designations to get those better tax benefits. Irrevocable trust can be set up as the beneficiary of a life insurance policy. You can pay more than one life insurance policy into the same life insurance trust. So, you think you've got one policy at work, maybe you've got a term policy and then you've got, an individual policy also, they can all pay into the same trust. It doesn't have to be separate ones for each. And then the revocable living trust as a beneficiary of a retirement plan. We've, sort of gone over this over and over again, but only even consider it if your kids are minors. Otherwise, you're just wasting tax benefits. All right, probate, big scary word that sort of doesn't necessarily mean a whole lot to people who aren't doing this all the time. It's just filing the death certificate and any other documents the court asks for to let them know that you passed. And then basically the court, again, just sort of takes inventory of your assets, make sure there's a plan for where they go, and make sure that plan is carried out. It can take a while. If you have a will, it's faster than if you have nothing. If you have a trust, it's faster than if you have just a will. It generally comes down to a cost-benefit analysis, as to whether you just do a will or whether you do a trust. But that's sort of, as far as the timeline goes, it's either, nothing and it takes forever, a will and it can still take, 6 months, 12 months, or a trust. And then even while they're going through the probate process, your trustee already has access to your assets. What does not go through probate? Again, anything that's in your trust, joint assets. So, if you and your spouse have a bank account together, if you and your spouse have a house together, a car together, Stuff like that doesn't go through probate until the second one of you passes. And then assets with a death beneficiary, like a, payable on death, life insurance policy, retirement, stuff like that. Do you want to avoid probate? Usually, if your estate is small, then maybe it's not such a big issue. For some assets, it's not a problem at all. For things like cars are super easy. The judge signs off on a, sheet of paper. You file something with the DMV, and that's it. So I generally tell people, don't even bother sticking a car in a trust. It's so easy to change. It's not even worth it. But it can just take a while. Like I said, sort of with the timeline issue, it can just take a while depending on, what documents you have in place and sort of the court's backlog. And that's the problem, is there's really no way to tell how long it's going to take, no matter what documents you have. Some things, if your estate does go through probate, sometimes some creditor claims are cut off that maybe wouldn't be otherwise. They're changing things so that is not an issue anymore, so that when the grantor passes, if you do have a trust, they're trying to change it so you basically get the same benefits both ways. So I don't expect that that's even going to be an issue for much longer. All right, now what? Okay, so it takes forever to make these decisions, okay? It takes forever to make the decisions that you have to make to have a trust set up, to have a will set up. I send out this 30-page packet, which sounds daunting. I promise it's not. It's 30 pages for a couple. It's basically 15 pages for each spouse. The reason I have separate set of pages for each spouse is because, especially now, we've got so many subsequent marriages. So we've got, different kids from spouse A than spouse B. So that way it allows people to decide, what happens with kids from different marriages. It also allows people to say, okay, well, like for my husband and I, he wants his sister to be his medical POA, and I wanted, I have my parents, I have 2 uncles that are MDs, and my best friend is a nurse practitioner. So, I had some sort of medical professionals on my side of the family that I wanted to indicate. So it allows you to sort of check a box and say same as client 1, same as spouse A, or you can indicate your own preferences, but just talk to each other. I can't tell you how many times I get somebody, they sign up, they want this estate plan, and then they're just like, well, I want this and she wants this, what do we do? And I'm like, I can give you advice, I can tell you what I think makes sense, but those are decisions that you have to come to either on your own or as a couple. So just, if you have a significant other, talk to them. If you have people that you want to be your trustees or your beneficiaries or your medical power of attorney or your executor, talk to them. So there are some situations where you may not want to talk to, if you have it. So let's see. I have a couple right now I'm doing the estate plan for. They have 3 kids. The kids aren't going to be the executors. The kids aren't going to be the trustees. Because they're beneficiaries and they all take equally, they expect that there will be a dispute as to that. So what they have done is remove the kids from those power positions and say, we don't want the kids to be executors. We don't want the kids to be trustees. We want someone else to do that. We want someone else to split it up. And then they've even gone so far as to say, I want a no contest clause so that if the kids fight it, they get nothing. So, make sure that whoever you're talking to is not going to, cause any sort of familial issues with. Calls. Most of us, myself included, do free 30-minute consultations for estate planning. It allows you to tell us, what you want out of an estate plan, what your family situation looks like, and have us give you advice so that you can, sort of weigh your options and decide what makes sense. I and most of my estate planning colleagues do everything on flat fee now. Basically what that means is if you come in and you say, I want to do a revocable living trust, that would include the revocable living trust, the will, the pour over will that comes with it, a durable power of attorney, a medical power of attorney, a living will, and it's all one fee. That means no matter how many times you call or email or ask questions or anything like that, there's no additional charge. It happened too many times that somebody said, oh, well, I didn't want to ask that because I didn't know if you would charge me if I asked you another question. And then not only did I say, okay, well, we can't sign these today because they didn't know what they were signing or they weren't sure about something. But it didn't make me feel good to, be giving somebody something that they weren't sure of. So here's my contact information. If anyone needs to get a hold of me, if anyone has questions, there's also a bunch of information about estate planning stuff on my website. Lots of, sort of pamphlets and stuff you can download with additional information on them. If you have any questions, feel free to ask Jeremy through the chat.
Yep. So we have 2 questions. Oh, actually, another one just popped
Sure.
up. How frequently should you be updating your estate plan? Is it something like anytime like a major life change happens, or?
Yeah. So generally, if your asset value changes massively, you've got to at least have somebody look at it.
Right.
So generally, what I do is I don't charge for any changes in the first 12 months.
Okay.
I also don't charge for things like changing a beneficiary designation. So or changing a trustee designation. So like if you decided you wanted you and your sister are now on the outs, you want your brother instead, stuff like that is super easy. But I generally recommend, like, if you now have a vacation home and you're not using it as an investment property, we need to talk. We need to sort of go back through things. Because it can really throw things out of whack with, making sure people get equal percentages or whatever percentages they're supposed to get for those, distributions.
Okay, cool. Someone was just referencing earlier talking about digital properties like social media accounts and like pictures. Sure. Does that stuff need to be included in the will, or is that, you'd mentioned like I guess it was a program where you can store passwords and stuff?
So it's called a password manager. There's a whole bunch of them out there. The one that I have is called LastPass. It basically gives you a place where you can log in, and if you log into this password manager, it then can log you into any of your accounts. But what I also have is like a fillable PDF where people can go in and type in the websites and type in their username and password, and that way you can just update it whenever you change passwords and stuff, and include it in your estate plan binder. But I generally indicate in there that whoever the trustee is, if you're incapacitated or if you're deceased, that they have that they have the power over your digital assets as well, because you want somebody to get that. Right. I mean, maybe like I don't care about my iTunes account, right? But I probably care about all the pictures of my kids. So
yeah, definitely.
Yeah.
Okay. And this is the last question. How much does a typical will and trust cost? I don't know if you can give out that information.
That's a loaded question.
This might be a bit more personal, but.
So I will be happy to tell you what the general fees are for things like that. Okay. So I do everything flat fee, like I was saying earlier. It's also on sort of a package basis. So like I have a revocable living trust package where you get a revocable living trust, the pour over will, durable power of attorney, medical power of attorney, living will. For an individual, it's $2,750 generally, and for a couple, it's usually $3,000. And then if you wanted a will without the trust, it's generally $800 and $1,000 for individual versus couple. And then there's also the testamentary trust, which we just barely touched on, but it basically allows you to sort of delay the distribution so your kids aren't getting everything at 18 without having to go through like the whole like revocable living trust, and that is $1,800 for individual versus $2,000 for a couple.
Okay.
So that's
awesome.
sort of ballpark.
Okay. Cool. Well, it looks like it's all the questions. So I'd like to thank you, Melanie, for your time, your
Sure.
expertise tonight, and thank you everyone for attending. And if you'd like to view this again, it will be on the LCPL YouTube website. So thank you once again.
Thanks so much.
Bye.